hybrid format pursuant to the House Order of June 23rd, 2022. Members are attending in person or in the room and remotely using the Zoom application. I'd like to make a few comments for the benefits of the witnesses and members. Please wait until I recognize you by name before speaking. For those participating by video conference, please click on the microphone icon to activate your mic, and please mute yourself when you're not speaking. Interpretation for those on Zoom, you have the choice at the bottom of your screen of either floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. A reminder that all comments should be addressed through the chair. For members of the room, if you wish to speak, please raise your hand. For members on Zoom, please use the raise hand function. The clerk and I will manage the speaking order as best we can, and we appreciate your patience and understanding on this issue. I'm just going to see if I have my, I usually have cue cards here, but I don't have them remotely here, so I will improvise. I will use a yellow book here. When I raise the yellow, that means you have 30 seconds, and I will raise a brown folder that says that your time has ended. So if you can watch those cues, otherwise keep a timer to yourself, that would be helpful. Just as in health and wellness check, before I introduce the witness, I'd like to inform the committee that due to the study on the agenda, some of you may find it difficult to listen to the testimonies presented and or experience discomfort given the nature of the topic being discussed. I'd like to remind our witnesses that agreed so kindly to appear in front of the committee, either in Zoom or in person, and members and staff, that if needed, resources are available to help here at the Parliament. The clerk will certainly help you, and you may contact him. I will allow, if necessary, a little pause for our witnesses in order to deliver their statement in the best environment possible. Our study could certainly be emotionally challenging for our witnesses, and we admire their courage to come forward and share those very personal situations. I'm sure our members will agree to that. I'll now ask our first hour witness to make their opening remarks for 5 minutes, and then after that we'll begin our round of questions. So our first witness is Tanya Sharp and Marie-Hélène Ouellette. So the floor is yours for 5 minutes.
Alors bonjour.
Yes, good morning. My name is Marie-Hélène Ouellette, and I have been a coordinator and counsellor at CALAX, which is a sexual assault centre in the Laurentides in Quebec for almost 20 years. L'Élan works with women and teenage women who have experienced sexual violence. We provide prevention, support, and advocacy. I've listened to much of the testimony presented here and wondered what I could contribute that would be different or complementary to everything that has already been said. I'm not a legal expert. I'm primarily an expert on survivors of sexual violence. The overwhelming majority of people who come to our centre do not press charges, don't file complaints, so they are not victims of crime per se, legally speaking. And of those who do press charges, many have a really harrowing experience, and a few are lucky enough to not have such a harsh experience. At the L'Élan, we have about 60 to 80 women coming through our doors annually over the past 20 years, and when there is a conviction or a finding of guilt, we celebrate at the centre, and you can count that kind of occurrence on the fingers of your hand. It's something that's a very rare occurrence. People who've experienced sexual violence have little access to justice, and in our analysis, the barriers to justice are either inherent in the criminal law or human in nature. So here are some of the barriers inherent in criminal law, which are substantive, and if the government really wants to provide adequate and meaningful support to victims of crime, there needs to be a profound rethinking of criminal law that needs to take place. The principles of the presumption of innocence, namely beyond a reasonable doubt and the burden of proof on the Crown, lead to an inequity of treatment. The system is designed, of course, to avoid convicting innocent people, which is a wonderful principle, but the unintended consequence is to leave a large proportion of guilty people free and victims abused by the process. Sexual violence is a frequent crime and one that is often committed in private. So for the Crown to prove beyond a reasonable doubt that the abuser or perpetrator is guilty is a difficult task in and of itself. Sexual violence is a crime that is too rarely reported, and when they do press charges, victims rarely come out satisfied with the process. Now, and I'm not just talking about sentencing, I'm not even talking about just sentencing. To make a difference in the unfair treatment of the parties, reverse the burden of proof in sexual violence cases. That's what I have to say here today. Now, regarding human factors, there are first of all sexist and racist biases, among others, some of them are unconscious on the part of the actors of the justice system. Social biases are numerous, significant, and really intricately linked to violence. The people who experience the most sexual violence are those who are disadvantaged by these biases that are produced by the various systems of oppression. We cannot separate the issue of victims' rights from the issue of social and gender inequalities. Victims of sexual violence are often women living with a disability, lesbian, trans, black, First Nations, etc. They are assaulted by people who are not women, and they are assaulted by people who generally have more privilege and more power. And the justice system is not impervious to these power relationships. Secondly, the lack of understanding of the actors of the justice system and how the brain works in the face of trauma. There is a real trauma biology, and how a victim is treated in the process can trigger traumatic reactions. For example, a very stressful cross-examination or one that lasts several hours can trigger a very stressful response and confuse the testimony, not because the person is trying to lie, but because a re-victimization puts the brain into a traumatic response that can cause memory loss, destabilize the victim, make her doubt herself, and with a principle in law such as quote-unquote beyond a reasonable doubt, it can be enough for justice to stop and cease taking action at that point. The response to a traumatic event can be varied. Some victims will have memory blanks, gaps in their memory, fuzzy memories, while others will have surprisingly vivid, clear and detailed memories. Those who have difficulty remembering are often criticised for not remembering accurately enough, while those who remember too well, quote unquote, are criticised for having such clear images that they must be making them up. The Canadian justice system must therefore take a hard look at the beliefs of the individuals who make up the justice system and not believe that the law is cold and objective. These beliefs have an impact in the administration of justice. The victim is considered a witness to such an intimate crime in the case of sexual violence that it puts the onus on the Crown to prove beyond a reasonable doubt the guilt of the perpetrator, who already has a lot of rights in that process. I repeat, I am an expert in survivors of sexual violence. These are serious acts of crime, and victims are not looked after. Criminal law and the administration of justice puts many spanners in the works and is an obstacle to victims getting justice. Sorry if I spoke too quickly.
Thank you. Appreciate your timely and conclusion. I would also like to just make a note. I apologize. I had said Tanya Sharp. Tanya Sharp, I believe, cannot be here this morning, so it was on the revised schedule. I didn't note that. I will now go to Mr. Moore for the first round for 6 minutes.
Well, thank you, Mr. Chair, and thank you to our witness. Usually we have a panel of witnesses, so you're our only witness today, but we appreciate your testimony. This is the last day that we're studying this issue on government's obligations to victims of crime, and we've heard much testimony about how the system as it is can be improved. But you said something early on in your remarks that I wanted you to expand on. You said at 60 to 80 women annually are coming through your doors, but there's a reluctance to press charges, and those that do often regret the decision. And you said it's not just at sentencing. So we don't, when there's a case that should be prosecuted and charges that should be made, these barriers to justice that people are hearing and causing them not to pursue, what does that look like? Where are they hearing about these barriers? What's keeping them from pressing charges? What are some examples?
Well, the various stages, for example, how the police receive them. Over time, we've seen police officers treat women better, these victims better, but often prosecutors are the issue. Oftentimes, we hear that prosecutors believe the victim but don't have the tools at their disposal to proceed with the prosecution. So that's a major barrier. That's where things get difficult primarily. And based on my experience, when these victims are speaking to police officers at the initial point of contact, they're being questioned, it's very harrowing for victims, very tough. And obviously, taking a more human approach would help things all the way throughout the process. I'm not sure if I'm answering your question.
That's excellent. When we studied a Bill C-5 earlier this year, we heard from witnesses that were concerned about the bill allowing perpetrators of sexual violence to serve their sentence in their communities. Is the fear of reprisal, how often do you feel that enters into the equation as to whether someone would pursue criminal charges or not, or someone who just, from hearing of other failures, decides not to?
Oui.
Well, yes, indeed. That is part of the issue. Those victims who asked help of the centre, well, it's because they've had the experience quite some time ago. So it's not necessarily fresh and new. So sometimes there is a fear of reprisal or retaliation, but that might be some kind of impact on their families or their entourage. But the victims that we take into our centre haven't necessarily experienced this in the near past, in the recent past. So they're not as afraid of retaliation, at least in our centre, that is.
Okay. And just some alarming statistics. Report published by Statistics Canada said that women were violently victimized at a rate nearly double that of men in 2019. But it goes on to say the discrepancy between male and female victims is largely due to the fact that women are 5 times more likely than men to be a victim of sexual assault. So, and you've acknowledged that in your remarks, what are some steps that we should be looking at as we prepare a report to go to for the government to respond to? What are some steps that you think we should be doing to address that glaring discrepancy?
Well, a response to a social issue requires social measures. And, of course, there's a lot that needs to be done. At our centre, we are going to great lengths to provide prevention and equal access to justice with a view to stemming and reducing these discrepancies. We see this as being part and parcel on education, on sexuality, and so on and so forth. So I don't think there's any magic wand that can be waved. I think that this should and must be developed over time. And when training is offered, I commend it. Awareness building, for example, about sexual assault is always worthwhile, and that kind of training really does work. For example, Justice Robin Camp, if I'm not mistaken, who a couple of years back acquitted a young man who had made sexist remarks, and at a later stage he did a training. He finally understood what his actions entailed, and he now, with retrospect and the benefit of hindsight, realizes that his own remarks were nonsensical, and now he's able to act and conduct himself differently.
Thank you. Thank you, Mr. Moore. And our next round of questions go to Mr. Naqvi. Mr. Naqvi, you have 6 minutes.
Merci beaucoup, Monsieur President.
Thank you very much, Mr. Chairperson, and thank you very much for your presentation.
Pouvez-vous nous dire
Could you please tell us how the judicial system could improve to better help victims of sexual violence? Well, earlier I spoke about understanding, the importance of understanding the trauma that victims experience. I think getting a better handle on that would be helpful. What is happening in the heart and mind of a victim who has memory blanks, and that we really understand that these are biological, natural reactions to stress. And just because you can't remember something doesn't mean that you are deficient in some way or not a worthy quote-unquote victim. And unfortunately, there is that kind of perception in society that to be a quote-unquote worthy victim, you need to have everything together. And unfortunately, the various players in the justice system are, in fact, complicit with that way of thinking. Is this victim a solid, reliable victim? Is this victim... And I think that it's important to understand the impact of stress on victims, first and foremost.
So in order to better understand victims of sexual violence so that their psychological and emotional circumstances could be better taken account for, what are your suggestions as to what we should consider? Is it around better training for those who are part of the justice system? Is it a change in the manner in which cases dealing with sexual violence are conducted in our justice system? If you can give us a sense of your thoughts on how can victims of sexual violence can be better accommodated, and accommodation may not be the right word, but I hope you get my meaning. Merci.
Well, of course I agree with improving training, but I think that we need to take a hard look at the power imbalance between the victims and the accused in the justice system. And I'm not sure how we should address that power imbalance in the system without really taking a hard look at the burden of proof about everything that has to do with the accused rights. Victims are the ones that are there testifying to the crime, and it's a difficult issue, but I'd invite you to take action on it.
It is a difficult issue, and when you speak of burden of proof in a criminal matter, in a system that has been around for such a long period of time and have been tested, that's a big question that you're posing. So I'm not putting you on the hot seat. I'm just acknowledging what you're saying and just keeping that in mind. Are there any other? The reason I also say this because I think that's probably beyond the scope of this committee's work as we are looking at the Bill of Rights for victims. Are there any other suggestions that you may have beside training that we may want to consider when it comes to protecting the rights of victims in matters of sexual violence?
Well, I believe, and I've heard a lot of people talk about providing victims with better and more information, better support when it comes to the impact that these crimes will have on them and the entire process will have on them. Prosecutors often have a role to play there, but victims need information even before they turn up at a police station. And it's not always easy to get one's hands on that information and to get accurate information, but it's important. And the prosecutor's role, well, sometimes the prosecutor will be really very supportive, but that's not really their role, is it? So how do we provide greater support to victims throughout the entire process? For example, when the victim makes their victim statement, well, there's a victim statement with a police officer in a cubicle in the first instance, which may be contradicted at a later stage in a later victim's statement or in a cross-examination. So the victim is often challenged in that sense.
Next, we'll go over to Monsieur Fortin for 6 minutes.
Merci, Monsieur.
Thank you, Mr. Chairperson. And good morning, Ms. Willett. I'm pleased to see you here this morning. I listened to your testimony and it was very interesting. And a little bit like my colleague, Mr. Naqvi, it's difficult to go about reversing the onus of the burden of proof. We live in a society where we don't want people to be convicted unless we are convinced of their guilt. We'd rather have one or two guilty parties in society roaming around than innocent people behind bars. But as you correctly pointed out, victims are often left by the wayside in our legal system and justice system. Now, I understand when you say that a victim of sexual violence might have a memory blank, for example, or be nervous or stressed and therefore unable to provide testimony that would be expected and reflect the credibility of the witness. So what kind of tools should be further honed to better support victims in their role as witnesses? Now, I'd also like to talk about information. You just touched on that. A lot of witnesses have said that victims are not really well informed about their rights, and that's a very important matter which is worthwhile of discussion in our report. Another point I'd like to raise with you, and that is victims' participation in the judicial process. In the court process, should victims be there present at all stages of the trial? Should they play a central role? Should they have a greater bearing on decision-making in the legal process? Now, in the case of plea bargaining, often that takes place between the defence attorney and the Crown prosecutor. Would victims, to your mind, consent to and be interested in participating in that process? Response. Well, when it comes to sexual violence, it's someone, in a sense, foisting their power and control over someone else. And the victim loses power in that circumstance. Now, the judicial system is such that the victim never regains their power. We need to empower these victims to show them that they really do have some power in the legal and judicial process, and that will be part and parcel of the healing process for them. When you're excluded from the plea bargaining, for example, well, it might be a bit of a bad surprise for the victim in the sense that they aren't able to have a fully fledged participation in taking back the power that's been taken away from them. Well, when it comes to convictions, I'm sure that 100% of victims would seek a conviction. But when it comes to sentencing, do you get the sense that were victims to participate in the sentencing process, based on your experience, would the sentences be different to what we are currently seeing in our judicial system? Or at the end of the day, do you think the sentences would amount to the same as they already are? Response. Well, it's a bit tough for me to answer that question. Obviously, on average, well, there are a number of sentences that are served in provincial penitentiaries, and oftentimes they are light sentences. Victims don't necessarily want longer sentences for the perpetrators. They want the keen sense that they were heard, listened to, and believed, rather than being seen as a problem themselves. So yes, sometimes the sentence is important, but not in all circumstances and contexts. Well, that's very interesting what you just said, Ms. Willett. Let me just come back to the starting blocks, if you will, and talk about helping victims, better helping victims throughout the process. What about, for example, a service where victims could consult a psychologist or a counsellor to help them get prepared before they have to testify in court? I'm not a psychologist myself, but surely there are ways to help victims be more comfortable in the courthouse such that their testimony is, well, I'm not going to say more sincere, because I'm sure that all victims are acting in good faith and testifying faithfully. But is there a way of helping victims to testify in a more fluid, organic, comfortable way where they don't feel under stress? What kind of professional services could be offered to victims? Response. Well, we, in our centre, in Quebec, provide that kind of support, and it makes a world of difference. We support victims from A to Z throughout the judicial process, and we know that that does make a difference to them and to the outcomes. We help them meet their objectives, not to get a conviction at all costs, but to break the silence, to break the cycle of silence. And we've seen positive outcomes from that. If there's someone sitting beside the victim, when the victim just can't cope anymore, there's a break, a short break, so that the victim can regroup. And so that's not just the prosecutor's role, is it? And unfortunately, these counsellors aren't always allowed to be there in attendance. Thank you very much, Ms. Willett.
And now we'll have Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair. It's unfortunate it's our last day of testimony, and Dr. Sharp is not able to be with us. And I know that the committee has made good faith efforts to try and get her here, and there were some family tragedies, actually, that prevented her from testifying. I just want to know whether we have received a brief from Dr. Sharp. Maybe the clerk can let us know. We have not yet received a brief. Okay, I will also endeavor to get a brief. Her work deals with the overrepresentation of blacks and people of color as victims of homicide in the Greater Toronto area. And it's something we haven't heard very much about before the committee. And so I think it's important we try to get some testimony through a brief from her. But I want to ask you, Ms. Ouellette, you made mention of this overrepresentation of racialized and marginalized people as victims of crime, and in particular sexual assault. Can you say a bit more about, not necessarily statistics, but about that overrepresentation that you see in your work?
En fait, on sait.
Well, we know that people with disabilities, people with immigration challenges, people who are sexually diverse, that they do experience more sexual violence in their lifetimes. Empirically, that's proven. Now, when I referred earlier, well, the perpetrator, the aggressor, is trying to demonstrate that they have power and control. And you can take power away from someone by sexually assaulting them. So it's all about a power imbalance in society, and that's important. A lesbian woman will be assaulted on the sole basis that she is a lesbian, for example. An Indigenous woman will be assaulted because she is an Indigenous woman. So you can't separate the experience of the aggressor and the aggressee out.
We have had some discussion at this committee on the question of coercive and controlling behavior, and the committee has unanimously recommended to the government that coercive controlling behavior should be made a criminal offence. Can you say something about what percentage of people you see who are victims of sexual violence from intimate partners, and whether coercive controlling behavior has played a part in that sexual violence?
Dans la clientèle.
Well, among the clientele of our centre, yes, there is a significant proportion of coercive and controlling behaviour in intimate partner contexts, but we do hear a lot of, for example, childhood issues, for example, such as incest or sexual assault during childhood. Obviously, coercive and controlling behaviour is a factor to an escalation in violence. That much is obvious.
You said that over time you'd seen some improvement in the reaction of police to sexual assault victims, and you talked a little bit about training. Are there other factors like changes in the composition of the police or other things that, as well as training, that might have contributed to that improvement? Because if there's improvement in police, we might be able to apply those same things in other parts of the justice system.
En effet.
Indeed. When I started my work 20 years ago, there was a police officer that said to me, well, we know that 3/4 of complaints about sexual violence are, in fact, not legitimate. And I was surprised that a police officer would believe that. And I don't think that that kind of thinking is as widespread as it used to be. There's training given to investigators, and I think it's working quite well. Also, sometimes the victims can request a female police officer that will take their deposition, and that is also helpful. I believe that training is important, but sometimes we've seen some police officers misinterpret the training they get. For example, where a police officer misinterpreted the directions and was more confrontational with the victim in their questioning and taking down of the deposition. But generally speaking, that kind of training is beneficial.
In the people you see in your work, is there an awareness of the existence of victims' rights in Canada before you were able to work with them? In other words, do victims have some idea that they might have some rights even if they're not totally effective?
C'est plutôt rare.
Well, not really. In fact, those victims that come to our centre oftentimes don't understand their rights, and that's part of our role to help them understand their rights. Oftentimes, they've heard about our centre or they've heard about victims' rights requests, and we'll support them throughout the whole process.
I just want to thank you for your testimony today. I think you expressed some doubt you were bringing something valuable to the committee, and I think all members of the committee would agree that, in particular, your emphasis on understanding the nature of trauma with sexual assault victims and how the system fails to do that. It's very important evidence before the committee. So thank you very much for being here today. Thank you, Mr. Chair.
Thank you, Mr. Garrison. Next, we have Mr. Caputo, and welcome to the committee, Mr. Caputo. You have 5 minutes for the second round.
Thank you. It's a pleasure and honor to be here. Thank you to our witness. I tried to explain in English. I was actually a prosecutor, and I focused primarily on sexual offenses, and particularly sexual offenses against children. So it's a real honor to be here. And I'm going to ask you about 3 tangible things, and I know we may not get through these in the next 5 minutes, but we're talking about steps that can be taken, and sometimes we talk in the macro, the big picture. But what I want to talk about is Section 535 of the Criminal Code, for instance. About preliminary inquiries, which means people testify twice. Second being video testimony, and 486.2 of the Criminal Code that allows somebody to testify from outside of the courtroom. And last, if we can get to it, the adoption of a statement under Section 715.1 of the Code. So I'm not sure if a lot of people are aware of this, but a preliminary inquiry is designed to ensure that there's enough evidence to go to trial. Now, preliminary inquiries were abolished for people who were charged with offenses with a 10 years or less in jail. Interestingly, sexual assault against an adult is a maximum sentence of 10 years in jail. So that person who is accused of that offense does not have the right to a preliminary inquiry. Now, if that sexual offense occurs against a child, for instance, the maximum sentence is 14 years in jail. Under the code, or for sexual interference. What I'm saying is this: a child who brings forward an allegation of sexual assault by indictment has to testify twice, and an adult who may bring forward that same allegation testifies once. This clearly makes no sense, does it?
Well, unfortunately, I'm not an expert when it comes to children, but indeed it does seem to be nonsensical. I work mostly with teenage women and adult women, so I won't venture to provide an answer, unfortunately, to that question.
It would apply to anybody under 18 generally. The second area is that a child who gives evidence is permitted to testify outside of a courtroom. And we call this in law a presumptive application, and it's made under Section 486.2 of the Criminal Code. And if a judge hears that application, they are presumed to make it, or they should make it unless they have a really good reason. Now, I'm using my own words here. But the same doesn't go for adults who testify. Now, we hear about trauma, and we hear about people who are, when you see the person who has offended against you, that must be incredibly triggering. Now, an adult can still make that application to testify outside of a courtroom, but when it comes to children, it is what we call presumptive, as in it's almost always made. Do you think if the application was presumptive, in this case it should be made with respect to adults, that would help adult victims because it would give them the right to testify from outside of a courtroom, and that's presumed, and there isn't that initial fight, and there's essentially the law is recognizing that you're already alleged to have been through so much trauma that we are not going to bring you face to face with your accuser, but you are just as much part of the process. In your view, would that be of assistance?
Je pense qu'on peut pas.
Well, I think the idea that you're floating makes real sense, and I'm not going to come out against it, but I listened to the testimony of a teenager who was able to record her testimony without being in attendance physically in the courtroom. I saw that work. It does work, and it takes a burden off victims' shoulders. Now, when it comes to adult victims, well, they too may be impacted by having to testify in person within the courtroom. However, some victims want to be there in person as a way of dealing with what has happened to them.
My experience as well is that some people want to be present. Now that brings me to the third point, which is, I think what you're referring to is it's under another provision of the code, 715.1, which is a child can actually say, can give a statement to a police officer, and if that statement is recorded, and again, I'm simplifying this, but if that statement's recorded and they say, yes, I made that statement, and yes, that statement is accurate, they don't have to retell their story. In other words, the statement itself is played. It is the telling of the story. It goes in place of the evidence. But that only applies to children. In the cases of sexual assault against adults, do you think that this would also be an effective measure to prevent or to assist not only in the trial process, but also in the facilitation of, not only the trial process, but in not re-traumatizing
Unfortunately,
the
Mr.
victim?
Caputo, we're out of time, so we'll have to wait on that. Ms. Briard for 5 minutes.
Merci, Monsieur le Président. Bon.
Thank you, Mr. Chairperson, and good morning, Ms. Willett. Thanks for joining us here today, and thanks for your testimony. You said in your presentation today that your main focus was prevention and victims advocacy, and that you're an expert in the area of the survivors of sexual assault, and that these women lacked access to the justice system because of limitations of this justice system and because of social and human factors. What do these women ask of you when they knock on your door? What are they looking for from your organisation? Response: well, we provide them first and foremost support. There are two very important things that we do on behalf of victims and for victims of sexual assault. We help them recognise and look in the face of what they have experienced and lived through, and we help them understand that it wasn't their fault, and there's an acknowledgement that what happened actually really did happen. And unfortunately, that's the main thing in the justice system. They want the justice system to understand that it's not their fault and that what happened actually did happen. That's a way to regain power in their own lives, to regain self-esteem. Unfortunately, this pervasive belief that what happened to them didn't actually happen to them, well, oftentimes it will be, for example, they will be told that perhaps X, Y, or Z didn't actually happen. But we tell them, listen, we know that this wasn't your fault. We know and believe you when you say that this happened. This is part of our advocacy work, our prevention work, and so on. When it comes to the judicial process, what are the roadblocks? Why do some women not report or press charges? Well, there's the fear that they themselves will be judged, that they will be questioned, that there'll be doubt cast on what they say. Why did you go to his home? Why did you dress in a particular way? So there's a pervasive fear of being judged, and also the fear that their testimony won't be believed. And in the support that we provide these women, we tell them, well, if your objective is first and foremost to break the cycle of silence, that is great, regardless of what the outcome is, regardless of, well, whether charges are pressed and charges are laid, regardless of whether the aggressor goes to prison, we will help you meet the primary objective of breaking the cycle of silence. We help victims understand that that will be cathartic and healing. Question: you put in place the PADI program, which is a French acronym for disabled persons. Could you please elaborate on that, please? How can you help disabled people who are victims of sexual assault and violence? PADI is a program that was implemented some time ago and focuses on a clientele of people with cognitive difficulties who have particular challenges when they are faced with sexual violence. They rely on other people, they rely on caregivers, and unfortunately, they don't get any education or very little education about sexuality, as if they weren't even entitled to have a sexual life. And unfortunately, that silence, that void, is filled by the aggressor, the perpetrator, which is very unfortunate. So we try to provide education about sexuality to them. Question: do you believe that the current justice system will help disabled people to press charges? Do they get the support they require? No, I don't think they do. Well, then what needs to be done to better help disabled persons who are victims of sexual violence? What's missing currently in terms of the toolbox of services provided? Well, the credibility of the victim is one consideration. When the prosecutor determines or assesses the victim's credibility, well, a victim with cognitive difficulties are not able to make their case, and sometimes their testimony is doubted and called into question. So I don't know what to suggest there.
We are.
Merci.
Next, we have Monsieur Fortin for 2.5 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chairperson. Ms. Willett, in 2.5 minutes, and I don't have much time, but I'd start with my final comment. Thank you for being here today. Your testimony is important and significant and meaningful. Now, very quickly, my colleague, Mr. Caputo, talked about children who are able to testify remotely outside the courtroom, on camera or by being recorded. And the question was, should adults victims enjoy the same privilege? But here's my question, and I know nothing about this. This is your bailiwick. But are there sometimes victims who prefer to confront their perpetrator? That this cathartic process of regaining control in their lives, I want to go there, I want to look him right in the white of his eyeballs. Are there many victims who want that, or do most victims prefer to avoid being put in that situation where they're face to face with their perpetrators? Response: well, some victims do indeed want to look the aggressor in their eyes to reclaim their dignity, and for others, reclaiming their dignity is more about being protected in the sense that they don't have to be there in person. Now, at your centre, you're on the front lines with the victims. Can you give me a sense, a ballpark figure? Do 90% of victims, for example, don't want to confront their aggressor, or is it 50-50? If you could give us a ballpark sense of what that looks like. Well, I think it probably is about 50-50. Unfortunately, I haven't empirically studied that issue directly, but I think it would be about 50-50, yes. Question: does it help victims when they are in the presence of their aggressor and they can set the record straight and tell him what they experienced as a victim, not just from a legal standpoint, but from a therapeutic standpoint? Absolutely. Absolutely. It's part and parcel of regaining control. All the principles of reparative justice are all about that. about being able to affirm yourself, about reclaiming your dignity, your control. In our centre, we have victims write letters. We have them write sketches up on the wall as a part of the cathartic experience, and that is crucial, yes. And I know I only have a couple of seconds left, but if I may? No, thank you, Mr. Chair.
Mr. Garrison for 2.5 minutes.
Thank you very much. We had some very powerful testimony a few days ago from women who had been victims of sexual assault who wanted to have the law changed so that they could be public and have their own names public, but also therefore the perpetrators' names become public. In your experience, would you believe that would be a good change to make to give victims that choice?
En fait, si je me souviens de...
Well, if I recall that testimony accurately, what the witness said was that they want to be able to have the choice, i.e. to have the choice as to whether or not that will occur. That's part of regaining their control, having the choice as to whether they want their name to be released and made public or to be kept under wraps.
When you're the only witness in the panel, you get a bit more of an intense experience with the committee than others do. So just in the remaining minute or so, I wonder if there's anything that you feel that you didn't get to say before the committee today that you would like to add.
Well, I think I've said what I had to say. I appreciate your attention to this issue and the importance that you attribute to this issue, that you have opened your eyes up wider and not just had a narrow focus on the Bill of Victims' Rights. And I'm grateful to you for having heard all of this diversity of testimony and all of the challenges that victims face in having justice rendered and justice done. So it was perfect. Thank you.
Thank you, Mr. Chair.
Thank you, Mr. Garrison. I'll next go to, if I can go to Teiko Van Popta, and welcome to the committee today, Mr. Popta.
Oh, good, thank you. I didn't realize I had an opportunity for a question. I'm so happy that I do. Ms. Ouellette, thank you for being here. Your testimony has been very helpful for the committee, talking about victims of sexual assault. Now, you highlighted the trauma that victims have to go through in testifying in court, and that perhaps a better way would be to conduct criminal trials would be to shift the burden of proof away from the Crown to the other way around. A couple of my colleagues have pointed out that would be a significant change from our tradition of the way we run criminal trials. My question is whether there would be perhaps a middle way, a third option, that at the victim's choice, the trial might be focused on restorative justice rather than a criminal conviction.
Effectivement.
Well, indeed. When I look at the impact of the traumatization and the re-traumatization, well, getting better doesn't necessarily equate to there being a conviction or a finding of guilt. But I think that in the judicial process, there should be a greater focus indeed on restorative justice. We know that it works. Empirically, we know this. And it helps in the healing process. And I trust that kind of restorative justice process intuitively. It's starting to gain momentum, and I do trust that kind of process, yes, I do.
Much for that. Would you be able to provide this committee with some examples of where restorative justice actually has been very effective in dealing with some of the traumatic experiences that victims have had? That'd be very helpful for us, I think. Thank you. I have a second question about education for judges. In the last Parliament, we passed a law that all judges must take sexual assault case training. Because not all judges were like my colleague, Mr. Caputo. Some were lawyers like me in a previous life doing land subdivision work. So education, of course, is always good. What do you say about that, about judges having to take mandatory sexual assault case training?
Alors d'abord, pour les...
Well, as far as reparative or restorative justice is concerned, there's an example of a victim who engaged in a process of restorative justice, who had left her initial aggressor and was in a relationship with a new aggressor. Now, for her, giving her the opportunity to speak out loud about the impact of the sexual assault on her, directly to the aggressor, had a very positive impact. It helped her to regain control, as I said earlier, and to hear that the aggressor's guilt was being acknowledged, that also was very healing. So yes, restorative justice does work well. You know, on the one hand, an aggressor might say, I didn't do this, I'm not responsible, and hearing your aggressor acknowledge that they did do it, well, that is extremely healing. Now, as far as education of judges is concerned, of course, I think better training is important, and I do think there needs to be an overhaul of the system to better overcome the kind of obstacles that are still in the way of victims, just in the sense that they can overcome their trauma first and foremost.
That's all the questions I have, Chair.
Thank you. Thank you. Next, we go to Ms. Briard Ms. Dillon for 5 minutes.
Bonjour, madame. Merci d'être venue.
Yes, good afternoon, and thank you for being here today. There are many of us asking you questions today, and you're alone, so a huge thanks to you. I'd like to start with your testimony, if I may. You said that sometimes victims are afraid to file a complaint, are afraid to press charges, that they are reluctant. Is there any psychological support that we can offer these victims, or perhaps they already receive that kind of support, and how can that be enhanced?
Alors, comme je disais...
As I said earlier, support is necessary. That much is certain. Now, I work for a community grassroots organisation. I know that organisations such as mine, well, there's about 30 in Quebec, 30 in Ontario, and there are not as many in the other provinces and territories. I don't know exactly what the depth and breadth of services offered is across Canada, but evidently providing more support in whatever form that takes is crucial. The prevalence of sexual violence is so great in our society, both male and female, because it is often the case that men and boys are sexually assaulted. But clearly, these victims, male or female, need support. Institutions such as the healthcare network are under so much strain currently that they're finding it difficult to provide that kind of service. We're talking about very subtle services here that in terms of support. And sometimes in the healthcare sector, when it's under strain, those are the first kinds of services that fall by the wayside.
Merci. Et des fois,
And sometimes the victim decides to withdraw their complaint and to drop the charges. Right? Perhaps they filed a complaint at the police station. At some point, however, in the process, they want to drop charges and the prosecutor doesn't agree, and pressure is put on the victim. Perhaps the victim has just had enough, can't cope anymore. We see that occur quite often. But there's pressure put on the victim. Is there a way of addressing that issue? Perhaps prosecutors need to better honour victims' decisions. In your testimony, you talked about empowering victims and how important that is. How does that all tie in? Response: well, that's only occurred once in my 20-year career. I supported an individual who filed a complaint and then decided to withdraw it, and yet the prosecutor went against that decision and proceeded, and the prosecutor actually was successful in getting a guilty verdict. Now, in that particular case, well, part of me wants to say, well, I'm a bit on the fence. I'm quite ambivalent. In that case, we're talking about a young teenage girl who had been assaulted by her father, who withdrawn her complaint. But yes, I'm torn because, of course, we want to respect what victims want. But I guess at the end of the day, I think we should respect the desires and choices of victims. Now, when they are being manipulated, that's where it gets a bit tricky, doesn't it? Question: do victims get other forms of support when they're being pressured by prosecutors, perhaps from their own attorney, psychological assistance from social workers and caseworkers, perhaps so that they can reconsider their decision? Is there that kind of support offered when victims are thinking about withdrawing their complaints? Well, that's exactly what we do at our centre. We provide a very much wraparound service, if you will, and there are other organisations, centres and services that offer the same kind of support. But of course there are waiting lists. And I think there needs to be better financial support of organisations like mine. That would be a good first step. Now, during your testimony, you said that 20 years ago there was a different mentality among police officers, that police officers believed that 3/4 of complaints were unfounded. So, and that there were perhaps awareness building and training that was offered. So what kind of training are we talking about to further improve the education of police officers and prosecutors? Well, we're lucky in the sense that since the Me Too movement took off, it's put a lot of pressure, brought a lot of pressure to bear across systems and institutions. And police officers are taking a closer look at this. And I think that there's been increased collaboration with police officers in my region, and I speak mainly for my region, but police officers call on us to discuss these kinds of issues. And I think that's great. The Me Too movement has shaken things up a bit. It really has. And I think that the training that's offered police officers is worthwhile.
I want to thank you, Ms. Dillon, and thank you, Ms. Ouellette. You're at the fullness of the hour to be our witness and express all your thoughts. I'm now going to suspend this, and we have our second hour as a in-camera business, committee business. So we'll suspend. We'll allow the witness to leave, and I will re-enter the Zoom through a different link. And if there's anyone else that needs to, may do so as well. Thank you.